My name is Nikki. I'm the founder of the Newborn Agency, where I help brands and creators talk to moms. So moms are my specialty. And I'm very excited to be with you here today. And I want to thank Auggie for hosting us. We are on the Auggie platform. I think most of you know who Auggie is, but it's a single platform where parents can find community, share recommendations and vetted products, and also join events and get more information and education to support you through what can be a very crazy, lonely time. So kudos to Auggie for making us feel connected and included. Thank you for enabling the waiting room, really. Shout out. So we are going to talk about estate planning today. I think it's one of those topics that is on a lot of new parents and expecting parents checklists as something to do. I also think there's a lack of information out there around estate planning and what it means, what you need to do, who can help you do it, where you can go for support. And so I'm so excited that we're partnering with Steward, a new platform that is helping families and individuals create estate plans. So before we get started and go through the conversation, I wanted to let our panelists introduce themselves, and then we'll get started. So Meg, do you want to start?
Sure, thanks. My name is Meg. I am head of customer success experience here at Steward. Originally from San Diego, but now living in Gloucester, Massachusetts. I am not an attorney. I don't provide legal advice, but I've been in the estate planning world for the past 6 years, primarily in this startup space, and have really enjoyed working with families, regardless of like net worth demographic or stage of life with having children. I've really enjoyed working with families all across the United States in creating an estate plan that means something and helps protect their family. So thanks.
Awesome. Thanks, Meg.
Oh, and
And
I am a mom of one. He's 2 years old. His name's Grayson. And he is just a little spitfire lately. We are very much in the twos
yes,
phase.
yeah.
Yeah, it's
Oh, and
wild.
I have a 4-year-old crazy boy as well. 4 doesn't get calmer than 2. And I also have a 15-month-old, Georgia, a girl who's very smiley. So very much in the zone. And yeah, Samantha.
My name is Samantha. I am head of legal at Steward. I graduated from Harvard Law School and immediately went into trust and estates planning. I worked at a big firm in the city, and then I transitioned into doing some more like boutique services, and then now at Steward. I do not have a kid. I do have a cat who I'm sure will make an appearance at some point, but we'll
Love.
see.
Amazing. Wonderful. Before we get started, please use the chat function, or I think there are probably, yeah, the chat function's great. If there are any questions, we want this to be collaborative. We want to make sure that you're walking away with the information that you need, and any clarifying questions. We will also definitely be a resource following the event if there's any personal one-on-one questions that you have for Meg or Samantha. So keep those, chat those, and I will make sure to kind of moderate through that as well. So let's get started with the basics. Why should new and expecting parents think about estate planning right now? Isn't this something you deal with later in life? Samantha, talk us through that.
Sure. So a lot of people do come to get estate planning documents when they're expecting a child, they've just had a child or going to have another child. That really is like the big impetus for people to start thinking about this planning. And that's, they're worried about protecting their children, want to make sure they're able to provide like long-term financial security for their children. But even if you don't have children or a partner or you don't think you have enough assets, it's still very important, and the documents are so flexible that it doesn't matter what your like life looks like at this stage versus what you think it might look like in 5 years. You want to start thinking about ways you can avoid family conflict in the event that you pass away. A lot of people's families can become combative if there's sort of a death and there's not ways to know what the instructions would have been. It helps you maintain control over your assets and sort of how things are distributed. It protects just your family, and it's just very important at all stages in your life to think about these things.
Totally. Meg, why does it give you peace of mind? Like, anything to add to that?
Yeah, I would say the biggest thing, like I still consider myself as a new parent. I think like once you hit the parent phase, you think about like everything in life, like, oh my gosh, what's gonna happen to my kid if this happens or that happens? But like most importantly, it's like what's gonna happen to my kid if like something happens to me?
Yeah.
And taking the time to like specify your exact wishes, like who's going to be the primary caretaker of your children if you're no longer there? And like something that we don't talk about a lot is like, well, what happens if I don't have an estate plan? And if you don't have an estate plan, you're letting the state decide what happens to your children and your assets. And no offense to anyone, but like, I don't want the state
Mm.
deciding what happens to my kids or what happens to my assets. I want everything to go to my son, and I want specific guardians in place for my children, my child, and future children. So definitely putting your wishes in place has given me that peace of mind. So in the event that I'm no longer here, my loved ones have the exact wishes of what I've wanted, what my husband and I have wanted, in the event that, yeah, we're no longer here. So
Yeah.
definitely gives me more peace of mind.
Yeah, and it's not something you want to think about because it's the last
No.
thing you want to think about. But, in this moment where you're bringing a child into this world, like we do have to think about that. And you want to be able to still have not control, but ownership over like making the decisions that you want for your kids, even if you aren't there. I think
100%.
there's a lot of like confusion around the documents, what is needed. I know for me, I mean, I was so, yeah, and well, Jackie, great question. What's the difference between a will and estate planning? That's where we're going to go right now, actually, because for me, it was on my list for 3 years. Like I had my first kid, it was on the list and I just like didn't know how to do it. And so I didn't. And then we were going away without my daughter. So I waited 4 years to do it. And we were going away without my daughter with my whole family. And I was like, how do we do this? Like it made me want to do that. But the process was really intense. It was pre-Steward, just saying. And also really cumbersome and really expensive. And also it was confusing because, a lot of people are like, I just need a will. And what I have learned is that there's more to it than that. So Samantha, can you talk to us around like the core documents you need? You hear trust when it comes to estate planning, and it's not just for the uber wealthy. You're like, I don't need a trust, I have nothing. So can you talk us through kind of those documents and what is needed and why?
So every core estate plan, regardless of what state you live in or what your assets look like, you'll have 4 documents: a will, a revocable trust, a power of attorney, and then a healthcare proxy. Sometimes it's called an advance directive.
Yep.
The will and the revocable trust are the 2 documents that together form what people think of as an estate plan. So these are the documents that work together. They appoint your guardians if you have minor children. They dispose of your assets. They direct how those things should go once you pass away. They can create trusts for assets to be held in trust for lifetime for your children.
And why do you need both? Why do you need a will and a trust?
Great question. So the reason why almost every estate plan now will use a will and a revocable trust is primarily due to this court process called probate. So probate is a process that your will has to go through. Every state has it. There's no way to get around it. And so you go to the court after someone dies, you give them the will, and then the court sort of supervises your entire sort of the administration and winding up of the estate. Anytime there's going to be a change to anything that you've created in the will, has to go through the court process. It's very time consuming. It can take a long time. I've worked on estates where it's taken years to sort of like wind things down, and it can be very costly. Another thing I know Nikki finds this to be very interesting is that the will is, once it's registered, like given to the court, it becomes a public document. So anybody can look this information up. And so this is why you see like on TMZ, people are always like waiting to find like the court document that was like filed for some famous person's estate. Whereas like a trust is just it's a private document. There's no court supervision. It just is a lot easier for you to control during your lifetime and for you to give control away after your death. So I guess I'll just like explain what the documents do. The will appoints the executor and the guardian, and then it says, okay, I want all my assets that I own at my death to go to my trust. And then the trust will just direct how things go. Most of the time it's to spouse, your children, whatever. It's very common for people to create trusts after their deaths for their spouse and their children, and this just provides it provides creditor protection. Number one, I think that one's very important. Like, for example, if your children get married and then were to get divorced, like the assets in the trust are not includable in sort of like determining alimony. And it just like provides like more protection. I guess I've been talking, I'll stop there.
No, that's good.
Okay.
And I think, and then the other two are obviously health proxy and what was the other one?
The power of attorney, yeah.
Power of attorney.
So the power of attorney is important. It allows somebody to just like access your financial accounts, do transactions on your behalf.
Yeah.
One that I think is important is like a real estate transaction. Someone else can sign your name. That exists only during your lifetime.
Right.
The healthcare proxy is very important as well.
Yeah.
I find this it's one of the simpler documents, but it's very important. It appoints somebody as your agent to make healthcare decisions for you in the event that you can't do so yourself. This just like really helps sort of like avoid conflict between like your parents and your spouse or whomever. And then it also allows you to sort of give like your wishes about how you would want to receive care in the event you can't talk to the doctor yourself.
Yeah. Yeah. And I think, thank you for this. And I think the clarity, and then Meg, I do want you to talk about Steward makes it easier because for me, I went through this with financial planner and then I got introduced to a lawyer and I felt like I just went through the motions, but didn't really understand, not that he didn't understand what I was signing because I am an adult and I need to like take ownership of that, but the reason for everything and why they exist. And also, for me, I found that these documents now live in a pile copy in my husband's office / safe because they should be in a safe, but they're probably not. And there's no way for me to like, what do I do now? And so Meg would love for you to talk through like how Steward is like simplifying it and also modernizing what kind of exists in the estate planning world right now from a white glove standpoint, right? Like there are ways in which you can get a trust and will right now. But how is Steward kind of differentiating who they are on the market as they're building?
Yeah, I think like from what I have seen, again, I've been in this space for the past 6 years. Estate planning as a whole is a very archaic process, and not much has really changed in the past 100 years. But I think that's when like the first will came out was like 100 years ago.
Is that true?
Anyways,
That feels
I
like
don't know. I could be wrong.
we
Yeah,
can look that
anyways,
up. We'll
but
fact
it's
check after.
very, very archaic. And so like over the past, like I would say 7, 10 years, have started to see more online ways to go about this, right? And a lot of them out there are very like simple documents, very like boilerplate. But the great thing about Steward is like we've taken really great technology and really amazing attorneys and paired them together. So now it's way more efficient for the attorney to add in customization specifically around a family's wishes. And it's more efficient and yeah, overall efficient for families to go through at the comfort of their home rather than like traveling to an attorney's office,
Yeah.
doing all of this
That was the
online.
most annoying thing that my husband
It's
and I had to go
ridiculous.
into New York City, get it signed in front of a notary and a witness. And I was just like, there's got to be a better way. There's got to be a better
I
way.
just talked to a family on Friday, and they were like, yeah, we went to an estate planning attorney and they gave us a physical piece of paper with a whole bunch of questions to sit down and like write out the answers to these questions. I was like,
Crazy.
it's not even a PDF or like a Word document.
Like a
Anyways,
fillable
so
PDF.
yeah,
Yeah, it's
I'm just like, that's
crazy.
wild. So it's like, I think like attorneys having access to this really great technology now allows them to support more families and like ultimately estate planning attorneys that I've met, it's like their ultimate goal is to support more families making these very complex decisions, right? And so it takes the burden off them. And it also takes the burden off the family having to like find an estate planning attorney. Like, where do you even go?
Yeah.
And then B, like traveling and doing all of the hard work, right? And then it's also a shorter process. So normally taking upwards of like 3 to 4 months to have your documents in hand. Now we've shortened it to be just a handful of weeks, a few weeks. Yeah, and
And also
then
price. I think trying to come in at a price that's,
much more
obviously,
affordable.
legal costs are legal costs, but I think Steward is trying to come in at a price that's as affordable for families as possible.
Correct. Yep.
Yeah.
And then we also provide more of that white glove experience. So going through the process, you're sitting down with a concierge member, myself, or a few others from the team, and we're doing that initial intake with you, providing that education right there on the phone. And then after that, you get to meet with your attorney, ask any legal questions. We finish the documents behind the scenes, send them over to you to review. Once you approve them, we will actually send out a notary with witnesses to your home. And then if you own property, we'll support you with transferring that into the trust as well. And that, going back to what Samantha had said before, that moving the property into the trust is what avoids that probate process.
Yeah.
Yeah.
Awesome. I think one of the things that is probably one of the harder conversations is the choosing of the guardian. So Samantha, what factors do you consider? And then Meg, I do want you to talk through Steward and how you're better supporting that process, but also like how things can change, right? Like to the point that you're saying it has to go through the court process to get things updated, but we can always make changes to who our guardians are. It's not a decision that's like set in stone for the rest of your life. But yeah, Samantha, how do you kind of what factors like should you think about?
Sure. And I mean, at the outset, of course, it's always a tough decision. No one thinks anyone else will do a better job than them.
Correct.
It's true. But a few things to think about is one is location. Like I've had people sort of want somebody to be the guardian or want to name a guardian, and I come to find out they live in like Germany or something. I'm like, I mean, yeah, that works, but now your child has to move to Germany.
I'm doing it like my kids would go to Los Angeles. Like,
Yeah.
They
Just
would.
some people don't care, but some people don't think about
Right.
those things.
Yeah. It was a thought, like we had to think about it, but that was ultimately the decision that we made.
Exactly. And just like to that point, everything should always just, as long as you've thought through sort of like the repercussions or consequences of your decisions, like the document should always reflect what you want after having considered all those things. Another thing is stability in like life stage. So a lot of people want to appoint their parents because their parents are in a good place right now where like that works for them. If in 15 years you don't feel like that would be the case, like, some people are interested in putting like an age cap or something, some health sort of indications.
Can you put like them until this age and then appoint them?
Yeah, you can do whatever you want. And whoever you appoint, like they can always say, no, this doesn't make sense for me. So then we always would suggest having a backup.
Right.
Another thing is like if you want to appoint your brother or sister or sibling, you can do that, but maybe they're in college right now, so that doesn't make sense, so just always be thinking about those things. Another one is like if your child already is sort of developing an emotional connection with a family member or a friend, like that's important to think about. Again, probably not something that like you want to think about or can really easily like decipher, but shared values and sort of like who you think would have sort of the similar types of values or parenting style that you have. And then overall, just like the willingness and capacity. You want to make sure that they're going to be responsible, like do what's right for your child to the extent possible.
But I do find that a lot of families like this down, like what stops them from doing this is like not having that person, like not having someone, right? And so it is about like having those hard conversations, like having hard conversations together, being like in a dream, if there were no factors involved that this person couldn't do it, who would it be? And then thinking through who to have those conversations with.
And the goal, right, is for this never to happen. We never
Right.
want guardians to actually have to be appointed.
Right.
But in the very unlikely event that that does need to take place, like it's better for you to have thought this through and made this decision than have to rely on the court process, which also can be very like emotionally draining for the children as well.
Yeah.
They'll live in this limbo state. It can be I've seen it.
Right. As hard it is to figure this out now, the alternative is
It's
harder.
much worse. Yeah.
Yeah. Meg, how does Steward kind of help through this process?
Yeah, I would say obviously we can't make this decision for you,
No,
but
you can't.
obviously happy
Help
to
make
be a
it
sounding
easier.
board. Yeah, and we also do a consultation for everyone that comes through where you can speak to a member of the team and like ask these hard questions. We send over some really great resources to start having that conversation with your partners or your family to figure out like what is going to happen in the event that you're no longer here. So yeah,
Yeah. And I
resources
also
and
think the nominal, there is a yearly fee that Steward kind of subscription, where to the back to the point, like, sure, if right now you don't know and your parents are of an age where for the next 3 years they could take guardianship, like do it and put them. And then I know Steward has a nominal fee where you can make edits to it whenever you'd like. So then in a year, if you have a family member or friends that you're kind of in a relationship with and have that conversation, you can then update it and change it, which I think is great to have that flexibility.
absolutely. Like your documents are supposed to be reviewed every 3 to 5 years. That's like the typical average of when people revisit them at the very least. And especially for like younger parents, it's like our parents, we're in that sandwich generation. We're taking care of little kids or children in general, and then we're taking care of our parents as well. So it's like life changes. So you can definitely make changes with Steward. We do provide that annual membership, which allows you to make updates really at any point.
Amazing. So I guess my last question is like, I mean, we went through how we make it easy, but what are common myths and mistakes? I think we spoke about it a little bit, but what do you guys find the common myths and mistakes when people are going through this process or kind of stopping themselves from actually doing it?
I think there's a few sort of common, through lines. One is like, I don't have enough money, or
I
like,
don't have enough to want to do it. Yeah.
yeah, or like I'm at this stage in my life, like maybe my life, I hope my life looks different in 5 years, and then I'll
Right.
think about this then. So a couple things I'll say to like, I don't have enough, or like what my life looks like now isn't what it's going to be. Great. But even like the smaller like net worth or smaller amount of assets, they have like a very big impact, actually. In fact, like I almost find that my clients who, um, it's important to care about these things, because even like a modest savings or owning a home or personal family items like a necklace that you love to,
Heirlooms. Yeah.
like,
Anything.
or a picture, it could be all simple things can have like a very big emotional connection, and it can cause conflict in your family if you don't have a plan in place. I've seen many families crumble under the pressure of like sort of having to make these decisions. Again, avoids the court headaches, because even small estates, those go through the court process, and it just really provides like peace of mind for you and your family. Another thing is people will always say, oh, there's still time, like I'll be able to do this like later in my life. I think we all are aware that life is very unpredictable, and things can happen that we don't plan for. And so it's just important to like make sure you're protected today and your
This is
family.
like one of the things you actually shouldn't wait for if you think about
Yeah.
it, because it's not like you're planning to die.
Exactly. And this is just one of those things where it's like you can cross it off your list and it will feel good, and you'll have like more peace of mind for like this unpredictable world, exceedingly more unpredictable that we're living in.
No,
And
it's,
it can always be
I
up.
think about it now because I have children, when I go on a plane without them, I think about it. Like I just do. Like it comes to my mind if something happens to me, like I just have more to lose. It's not just me. And that's reality. And I think it's a really hard conversation to have. but that's reality. And instead of feeling anxious about that, what's going to happen to them? And obviously you're still anxious, even if you don't have these documents, but at least you are making, you know, you are setting them up for the, like, as much success as you can in a really, really, which would be a really devastating, terrible situation.
Exactly. So
Yeah.
I just think it's about preparedness and sort of making yourself feel better, making your family in a good position. I just think there's never a bad time to at least start having these conversations and thinking about how things that you want, because again, these documents are meant to be flexible and work for you as long as possible, and are also always, you can always change them.
Exactly. Meg, what do you find is the common myth? I know the thing, I don't have enough. We like, one of my friends literally came to, it was like, I don't have enough, I shouldn't do this. I was like, can you please just speak to Meg?
I was gonna say like the assumptions. Like I think like everyone always assumes that everything you own will automatically go to your children or go to your spouse or your parents. And sure, like while part of that might be true, a lot of it isn't. And like even with your children, like, oh, my kids are just gonna go to my sister. It's like maybe they're not.
Right.
So really like specifying those wishes is so important. Dying, Sam and I were talking about this before, but like dying without a plan in place can actually be way more
Yeah,
expensive
I've heard
than
that.
just creating your trust. Like what people don't talk about is the cost of probate. And it's generally like a percentage of your entire estate. And every state has different probate fees, but like we're charging $3,000 here, which is such a small fee compared to the astronomical fees that probate has. So,
Yeah,
yeah, I think like a lot of people don't realize how expensive that whole process is and just complicated.
and complicated, yeah.
And I think to your point, Meg, it's like having to go through like sort of the arduous process of trying to find a lawyer, trying to like figure out who
Mm,
the right person is, what to do, pay those fees, like there's so much there. It would be silly for us to say that there was no work involved in sort of like going through this process, but Steward has really like simplified it in a way that I think is like much more digestible and like it's more easy to navigate in a way that I find to be very impressive. And like
Oh my God.
however long I've been doing this, I find it very impressive.
Yeah. Last question I have, because it's come up, and I don't know if it applies to anyone, but I do think it's a good one to answer is what special consideration should someone have if the family is blended, like a spouse has another child, or like how does that work for creating, like, is everybody under one? Do you have to like co-will and trust? I don't know.
That's a
Do
good
you know
question.
of like any teenagers or anyone in the building?
I was
Someone,
thinking of him, but he's so good.
I don't know who that is.
I mean, either.
Okay, is someone off speaker? Maybe it's Lily. I don't know. Okay, go on.
Sure. So it sort of just depends on what you want, right? Like I've had blended families come in and say, we want to treat all children equally. So that requires the document to do that because stepchildren are automatically entitled to anything under state law. So if you want them to be included, you must like create a document to do that. Other times they say, I want, you know, everything to just go to my kids. I don't even want my spouse to get anything. It's really just about sort of like how you feel in the situation. So the documents are tailored to meet your wishes. And I know this like this is a very like lawyerly answer that it depends, but like the way that we would draft the documents or the documents would be drafted to handle these situations just depends on what you want, and we can always sort of modify and mold and make the documents whatever it is that you're trying to accomplish in this situation. But yes, blended families, the short answer is would require special consideration and drafting,
Cool. But that's the
and which is
beauty of being
easy
able to
to
do a
do.
custom
Yeah,
document,
exactly.
which can happen. Amazing. Does anybody, I haven't seen, I hope I answered your question, Jackie. If not, please ask another one. We have a few minutes for other questions, but if not, I guess while we wait, we're also doing a little bit of a giveaway at the end of this. Anyone here, which we will pick random. I guess I can just pick randomly to win a wine gift set, so you can kind of have these conversations over a glass of wine to make it a little bit easier and lovely, because I mean, I do think you have to set aside time to have these conversations with, you know, if you are in a partnership with your partner, to really make the best decisions for yourself. So I am going to randomly pick Naomi Co. So Naomi, I will get your email from Lily and we will get your address to send that to you. I'm not seeing any questions come through. Meg and Samantha, again, will be available. Oh, you have a question. Paulo, go ahead. Wait
Is
for
it okay to unmute?
Oh yeah, unmute. Great.
Okay, okay,
I didn't know that was
great.
possible. What a function.
I don't
Great.
know. I'm sorry if it's not
Go
allowed.
for it.
Okay, so um, so as somebody who's an immigrant, moved from a different country and has dual citizenship, what you how would you advise? Is it advisable to have some kind of will, or some kind of, you know, whatever paper, I'm not sure what the right term is, in both countries or the country of residence? Like, what happens if God forbid, something happens on a trip abroad? You know, like what legally, like what prevails?
That's a great question. It depends is the answer. But there's a couple considerations, right? So there's tax implications, and then there's sort of just the probate and guardianship and implications. Wherever you live, your country of domicile, that would control sort of the probate, the guardianship proceedings, all of that. So for all of your assets here and your children, if they're here, that all goes through the US court systems or through your US documents. There's also just like the US is one of like two countries, I think the other one's like Eritrea, that taxes citizens on their global assets, even if they don't live here. So there's also just sort of like, we don't have to go into the details, but there are like tax implications to being in both places, but somebody can help you navigate that in terms of trying to find what like the best planning is for you.
Amazing, thank you.
Of course. We have a few others. So Matthew, you want to unmute and ask your question?
I think my question somewhat just got answered, as you can probably tell by my accent.
Oh, amazing.
Australian. And we're just trying to work out whether we set these documents up in the US and Australia, as we'll be moving back to Australia in December of this year. But it probably sounds like from a tax implications purposes, we might want to set that up in Australia. So Sam, I don't know if you wanted to add anything further to what you just described.
I think without knowing like any situations, it would just be something you'd have to obviously like talk about with a lawyer. But yeah, it's probably, it depends. I know that's like, this is the worst answer, but it does depend. But yeah, I do think like these are good things that everyone's thinking about. And we are living in, you know, a world where many people are from many different places living in the US. And so if you're not planning to stay here for a while, then it might make more sense to think about where you're going to be living, but it depends.
Yeah.
Right. No, that's
Giving
helpful.
like legal advice. Yeah.
Amazing. All right. Thank you, Matthew. Kaylee, do you want to ask your question? Or I can read it
Hi.
here. Oh, go ahead.
I was just curious about if there's a split custody situation, or specifically a situation where one parent has full custody and the other parent does not have custody. Can a will still specify a preferred guardian in place of that parent, or, I mean, the other parent who doesn't have custody, or would the kids go to the other parent?
That's a good question. So typically when it comes to guardianship, the appointed guardians come into play only if both like natural guardians, so the biological parents or adopt whoever is the parent, both parents are like not able to care for the child. So that could be in the case where both parents pass away, or the other one where a parent has sort of been like stripped of their parental rights. In that situation, then the person named in the documents would be sort of given to the courts, and the courts would decide if that made the most sense. But while one parent is living, as long as they're still sort of recognized by the court as having parental rights over the child, they would always get, preferential appointment. I don't know if that answers your question.
Yeah, that's helpful. Thank you.
Awesome. Thanks, Kaylee. Does anyone else have another question? Thank you for participating, everyone. I really love supporting individual questions too through this process, because I know it can be a tricky one. But if no one has any other questions, again, we will be sharing more information on Steward, giving the Auggie community a pretty great discount also for anyone that wants to sign up using Steward. It's $1,000 off the $3,000 fee through the end of the month. And then you can also book your onboarding call. I think it's within 3 months from there, so you don't have to do it immediately. You can still get that rate for this community. So thank you, Meg and Samantha. Thank you, Auggie, for hosting us. And we hope we helped a little bit in this estate planning crazy world and make your life a little bit easier. But thank you, everyone.